evening. You're welcome to State of Affairs on GhOne TV. My name is Abina Owusu-Nyamiche. Tonight I'm sitting in for your regular host, Nanaba Anamwa. This program is streaming live on YouTube. That's at GhOneTV.com. Tonight, we're getting legal and we'll be looking at the Supreme Court's order to the Electoral Commission to clean up the current voters register. How can this exercise be carried out devoid of any chaos? And we'll also take a look at a declaration by the same court, that's the Supreme Court, that Section 967 of Act 30 is now unconstitutional, thus all criminal offences are henceforth bailable. I'll be joined by two seasoned lawyers from the NDC and the NPP to dissect the issues with us. You can be part of the show from wherever you are watching us from by sending us your contributions and questions via our social media platforms using the hashtag State of Affairs. Before then, let's update ourselves on the ongoing limited voters registration exercise. The NDC parliamentary candidate for Clotte Colley, Dr. Zenator Rawlings, has commended the Electoral Commission for rectifying challenges faced during the first phase of the ongoing limited voters registration exercise. Dr. Zenator Rawlings has also called on all new applicants to show interest in the ongoing exercise. Here's a report by Joseph Armstrong Gold.
Dr. Zenator Ajiman Rawlings, who was touring some registration centers in the Clotte Colley constituency, expressed satisfaction about the ongoing limited voters registration exercise.
Gotten better. The second phase, we've seen a lot more people coming into the centers. The workload has increased for the EC officials. The process is actually quite tedious, so it's taken quite a lot of commitment on the part of the officials of the EC to actually get this job done. And actually, in this constituency, we haven't had many issues. You know, we've managed to resolve most of the little problems that occurred here and there with little misunderstandings and so on.
She called on the Electoral Commission to pay close attention to densely populated centers.
Some centers where there are a lot more people coming in than others, and I think it really has a lot to do with the population density in some of those areas. But I think we will see a lot of people coming in over the weekend because it's the last 2 days, tomorrow and on Sunday. So I think the workload is going to increase quite a bit. But we hope to keep the process moving and on all sides be responsible and make sure that there's peace in the various centers so that it can happen.
She also commended the NCCE for the public education, but believes they could have done better.
I think a lot more could have been done and a lot more could be done in future. I think perhaps in future what we need to do is start actually putting the word out a lot sooner than we did this time around, just to make sure that we get the information filtering through to the various people in the community. But it's still better than nothing. We've had a lot of people registering, so it's a good sign.
The limited voters registration exercise started on April 28th and will end on May 8th this year.
And you're still here on State of Affairs. This is GhOne TV. My guests are seated. But before that, 8th May is Mother's Day, and she was first your mother and will always be your friend. Send a 2-minute video telling your mother how much you appreciate her. Tell her why she's the best mom that ever was. Tell Mama one thing that will always make you love her and always be grateful to her. Here at GhOne TV, we are simply loving our mothers, and so should you. So say it all. Send us a video via any of our social media platforms at GhOne TV on Facebook, Twitter, and Instagram, or you can send it via WhatsApp. The number is 0231 144 272. I'll take it again, 0231 144 272, and say thank you to Mom. So we'll be looking forward to that video celebrating your mother on Mother's Day this weekend. So as I mentioned earlier, my guests are seated. They are two seasoned lawyers. We are all legal this evening. I have Gary Nimako.
Hi.
Thanks for joining us.
Thank you.
And also Godwin Tamaklo, and he is also the Deputy Regional Youth Organizer of the NDC in the Greater Accra region. You're welcome.
Thank you, my lady.
And so you can be part of our conversation using any of our social media platforms at GH1 TV on Facebook, Twitter, and Instagram. Don't forget to use the hashtag State of Affairs. So the matter at hand, the first one is about the voters register. The former national youth organizer of the PNC, Abu Ramadan, took the matter to court. Yesterday, the Supreme Court made a decision on it. So that's the first issue we are tackling this evening. And let me begin with GhOne. You were in court. Tell us what the courts say, actually.
Thank you very much, and let me use this opportunity, being the very first time of appearing on this wonderful platform, to say good evening to our cherished viewers and your able, assistants. Now, I sat through the reading of the Supreme Court decision relative to Abu Ramadan, Evans Nimakon, and the Attorney General and the Electoral Commission. Roundly, let me say that the entire action was brought to the Supreme Court, and the plaintiffs were asking for specific reliefs. Now, the first relief was that upon a true and proper interpretation of Articles 42 and 45A of the 1992 Constitution, the Electoral Commission is mandated by law, as it were, to compile a register that is fair and transparent, to a declaration that upon a true and proper construction of Article 42 of the 1992 Constitution, the current voters register compiled in 2012 is unconstitutional, as same is inconsistent with Article 42 and therefore null and void. And once the Supreme Court takes the view that the register is unconstitutional, then a further order be made setting aside or striking down the said register and a new one compel, an order on the Electoral Commission to compile a new voters or a fresh voters register. Let me say that the Supreme Court,
in the alternative.
Yes. I'll come there. In the alternative, to order for what you call a cleaning up, or more or less, or a certain validation of the register. Now, on these grounds, the Supreme Court roundly disagreed with the plaintiffs and therefore dismissed the most prioritized relief, that is to say, declare the register unconstitutional and order the compilation of a new one. So on that score, the Supreme Court disagrees. And in fact, in the concluding statement of His Lordship Justice Benin, he gave only a concurring, what shall I say? He said, it is for this brief reason that I fully agree with the decision reached in the case, that the plaintiff action be dismissed insofar as it seeks to order to compel the first defendant to compile a fresh register, as you get it. So that, for me, concluded the whole statement. But then certain orders were made relative to the same decision. The most striking one is the fact that the Electoral Commission should immediately take steps to delete or to clean up the voters' register. Now, what the Supreme Court further stated is the fact that at all material time, this process of cleaning up must be a process sanctioned by law. Which processes are sanctioned by law, the court more or less left it there. I want to believe that they are generally accepted processes for the purposes of cleaning up or deleting names or persons who are not eligible to be on the register. It's also important to make the point that the specific reliefs, that the plaintiffs were asking that the validation should be done in a particular manner, the Supreme Court took the view that doing so would amount to more or less interfering in the independence of the Electoral Commission recognized under the 1992 Constitution, because the plaintiffs had set out a certain way. The court took the view that these ways are not sanctioned by any law. They are not even recognized in any law. So that to the extent that they are not recognized in any law, compelling the Electoral Commission to act in that particular manner would amount to a certain amount of interference in the independence of the Electoral Commission.
What exactly is the procedure that the plaintiffs were asking the court to grant the EC to use in the validation process?
The plaintiff in their statement of case more or less used the Nigerian approach, more or less, where you'd go, if a person is so and so, you take the name out, or if you have risen, or myself and Gary can just come and say, oh, this person, we have grounds to believe that he is not a Ghanaian. And in fact, in the words of Professor Jega, who did the Electoral Commission of Nigeria, yes, he said in Nigeria what they were doing was effectively to just allow persons to come and say this is a minor, this is it, and on that basis the names are deleted.
So you can walk up to any registration center
effectively
and just pinpoint that
it may not be a registration center, but the Electoral Commission office.
Okay.
What and on this ground, the court said no. Let the Electoral Commission use the processes sanctioned by law to have these names deleted or to clean up the register. Fact is, when you say clean up the register, for me, it still leaves a lot of issues. It then goes back to the Electoral Commission to determine how best, under the circumstance, to clean up the register. Now, let me also say this. For all intent and purpose, the court agreed that the current register as we have it, we cannot say is 100% clean. To the extent that from 2012, when the register was compiled to date, there's a real possibility of people dying, then it then means that you're going to have the names of dead persons who once registered to be on the register. There is also the possibility of having minors on the register. Now, to this end, the court then took the view that the birth and death registrar and all these allied agencies should team with the Electoral Commission to help this. And I think that these are processes that ordinarily are sanctioned by law. Insofar as you can go to, at least your relative is no more, you can just walk to the Electoral Commission and say, on the basis of this proof of death or burial permit, I think, or what you call obituary or something, I think that this relation of mine should no longer be on the register.
Yeah, but it's something that people do not do.
And that should be our civic responsibility relative to making sure that our democracy gets better. I mean, the whole electoral process gets better.
We'll be getting into all that, but let's carefully take a look at the issues that the Supreme Court raised. And now, the court is asking that the EC delete names of the dead, minors, and those who registered with the NHIS card. Gary, how do we detect that this person registered using the NHIS card? Because clearly, personally, I don't remember what I registered with.
Very well. Let me say good evening to your cherished viewers. And let me say that this decision which came yesterday is a very good starting point. As a matter of fact, there have been several concerns about this, the state of this electoral album. If you recall, I think somewhere in 2014, that is when this Abu Ramadan first case came up. And I quite remember that the relief even to delete the names of persons who use NHIS card at that time was contained as part of the release before the court. That if the court were to find that the NHIS card is not a good qualifying document to put yourself on the register, then as a consequential relief, the court should make an order to delete all those people who use that document, their names from the register. At that time, the court, was not in agreement with the plaintiff. Now, you also recall there were several agitations in this country let my vote count, or in other civic institutions in this country, that the state of the voter register is not in a good state which we need to use to conduct these elections. Now, let's not forget one thing. You see, the parent document that you are going to conduct elections on is this voter registration document.
Yeah.
If for some reason that document is in dispute, it is important that that document ought to be cleaned up in a manner that when elections are conducted, persons who are the main actors in this election will not come and complain and say, well, in our view, the album has been padded. That's the reason why we lost or we won the elections. You understand? Now, the EC has taken a certain position, which I find always problematic. That, well, we want to have our own way of doing the way we want to do the thing, the way we want to do it.
It is an independent body.
You see, the independence of the EC is subject to the Constitution. And the decision of the court is they made it very clear. Article 23 and 296, it tells you that, look, you cannot do things in a manner that's capricious, that's arbitrary. If you are independent, it doesn't mean you can do whatever you want to do, or you can do things ultra vires your power. You understand? EC is independent, that is fine. Nobody's challenging that. Even the Supreme Court made sure that it didn't veer into the arena of the independence of the EC. They're very, very clear about that. However, your independence should be exercised in a manner that at the end of the day, you act within the law. Period. Now, we have had complaints about this voter register to the extent that even there was a demonstration that one person had to lose his one eyesight because the EC says, well, we have a way of doing our own thing, we want to go this way or that way. But the EC self admits that people use NHIS card to register, and that document is no longer a qualifying document to put yourself on a roll. The EC self admits that, look, there are dead persons on the register. The EC admits that there are minors on the register. What mechanism, subsequent to 2012 and 2013 election petition, did it put in place to ensure that these concerns were addressed by itself, not even by anybody, by itself, to delete these persons from the register? Now, this ruling having come, I have read the entire judgment, and I think it's a very good starting point. First of all, there's an order, delete the names.
Yeah.
But delete the names with notice to the people. You see? For instance, if you are now here and then before you hear they say they're going to delete your name from the register, it is possible that you have the right to vote. It is possible that you're a Ghanaian. It is possible that though you have the NHIS card, you still have another document which makes you qualified to put your name on the register.
But how would I know that I'm going to be affected?
That's why you read the judgment carefully. It's the judgment. That it is due to be because the people entered the roll. Another time that the document was a qualifying document to put yourself on a roll. To delete their names without notice to them will be unconstitutional. And you'll be disenfranchising them from. So you see, you must do it with notice to them. That is why the EC, you realize that the court did not want to veer to say, go and do it by this manner, or go and do it by this way. Maybe the court was a bit mindful that to say do it by this way, they may more or less be entering into their independence. They say, well, more or less show them how to do their work, more or less. All right? But the EC has admitted in open court that they know the people who use the NHIS card. Don't forget, there's a certain form, we call it Form 1C. That form, or Form 1A, Form 1A, it's a C, isn't it? Now that form, if you are registering at the centers, they ask you of your document that you are using. That document, they ask you if you are using the NHIS card, they take. If you are using the voter ID card, they take. As the existing voter ID card, the one before the old one. Passport, they take. Or driver license, they take.
So it can easily be
So the question is, if that document that they say they have, if they are still in the districts as we speak, then it's good. It means they can just recall all those documents, and then you can see the number of people who use NHIS card. Maybe publish a list, and then say, well, these are the list of persons who we are going to delete your names because you use NHIS card. Now, the issue about dead persons. How would the EC itself know that maybe person X or person Y is dead? I think the EC sitting there by itself might not know. Somebody may have to report to the EC with a certain document that my family member or my this or my that is dead. It is possible. Or the EC liaising with birth and death registry And in these countries, most of the time you realize that people even die, they don't register it.
Yeah, we have an issue with data collection.
Exactly, they don't register it. So I think, and even the minors, for minors, you can look at their facial, looks. But sometimes somebody might be an old person, but might have a baby face.
But if in 2012 the person was, let's say, 16 years, in 2016,
no,
the person qualifies.
no, you don't. You see, the difficulty that we are having is that if the person was 16 years at the time of registration, yes, now you qualify, but at the time of that registration, you did not qualify. So your name ought not to have been on the register in the first place. So that name ought to be deleted immediately and then be given a chance to register. Now, that is why the panel of experts, they said, if people did registration who were minors then, give them what they call, they call it, was it a moratorium? No. They use a certain term. More or less, they don't punish them. All right? So that they can come back now and then register, and have their names on the, so they have their names on the roll now. But basically, I think that looking at the way that this decision has gone, if the EC is going to implement it now, which is safe, it's a forthwith, immediately, it means forthwith. It means by today, they ought to have started working on how to implement the ruling. You understand? If you look at it carefully, it's a lot of work for the EC now.
It's a lot of work.
A lot of work.
We'll be getting into that and its implications on the elections. But still on the issue of the NHIS, at that time, it was accepted. So the issue of fairness then comes in.
In fact, the court had a good answer to that particular question to make the point that at the time when it was registered, remember that it was permissible under CI 75.
Yes.
Now, because it was permissible under CI 75, it was lawful. So that registration then was lawful until it was declared unconstitutional in 2014. That unconstitutionality does not and should not be used as the basis to deny them that fundamental right. That is why the court proceeded to say that even in the event that you are having to delete them on the basis of that, immediately have them register. Because, you see, what we need to know is that electoral laws, even for the purpose of construction and others, are more or less construed liberally. Because at the core of that is a right from which all other things emanate. The decision as to where resources should go emanate, first of all, from the exercise of this right to vote. So the court, being so cautious, indicated that at the time, it was right to do that registration using the NHIS card. But today we are saying it's unlawful. And that is the reason why they even describe that on that basis, the register is unreasonable, having to do with the fact that this existing, but you see, it raises another constitutional difficulty, which is to say, some persons have accrued rights under an impugned legislation. What do you do to those accrued rights? Do you cut it off immediately? Because the right that have accrued under a legitimate law, as at the time, what do you do? It creates a certain difficulty. But like my brother indicated, even implementing aspects of this ruling raises some difficulty. Like the Form 1C, as he pointed out. On the face of the Electoral Commission data, you can see it. However, there are manual processes of that registration that is kept at the respective polling stations. So we are talking about 26,000 polling stations. Is it the case that we are having to go to the respective polling stations and put out there that Kwejo, Ama, so you register with the NHIS. Come on this day to come and re-register. It raises serious implementational challenges. And I want to believe that that is why in the superior wisdom of the justices of the Supreme Court, they did not proceed to say that EC, conduct your affairs in this particular manner. Let us also make this point clear, that the Electoral Commission itself has always had a means of making the register even cleaner by way of its own exhibition, among others. Now the question is, the exhibition process, is it effective for the purposes of making the register more credible? That is the question that we should be faced with relative to this current decision of the Supreme Court. I foresee real challenges going forward. Because I have seen Ben Epson, and I can associate him because I just heard you make the point, and he isolates regional breakdown of persons who might have registered with NHIS. He says in Ashanti region it's 92,000, Volta is about 10,000, Eastern region is about 32,000. He's given about 4 regions so far. How are we going to look for this 92,000 Ghanaian voters in Ashanti region for the purposes of deletion, for the purposes of cleaning up? It raises real challenges. I think that the most important thing, and I still maintain, that they have accrued certain rights, and those rights that have accrued to them, going forward, we should have a way of maintaining those accrued rights instead of a blank, like a painter with a brush, painting everything, delete everything. Let's do it in a manner that will not create difficulty. Like you rightly pointed out, what document did you use for the purpose of registering in 2012? You cannot easily remember.
I don't remember.
Absolutely. So that if, for instance, you work in Accra, but you registered somewhere in my village, or say in a village in Kwe, the northernmost part of, in Kwanta in the Volta region, just by the Togo border, and you are saying that I use NHIS, and for that matter, my name should be deleted. Now you've moved to Accra, you're working. Look at the process of going back. If it is, posted there in Kwe, how would you know if you are in Accra? So I personally have a certain challenge with that aspect of the ruling on deletion, because it has real implementational challenges. We may succeed in just disenfranchising people, which the Supreme Court has said they do not want to move into the arena of their ruling becoming a tool to disenfranchise people, because it's a very core fundamental right, the right to vote. In the past, they will tell you, in nations, Greece, and whatever, the right to vote is the only thing that distinguishes a slave from a free man. That is how fundamental that right is. And all of us must protect it.
Gary, the court didn't state when. He did say that immediately. And we have just 6 months to elections.
Well, you see, immediately, in law we call it forthwith. That's why I said, reasonably, I would have expected the EC from today to start working on this matter.
But even with the ongoing limited registration exercise, there are issues. Somewhere in the western region, yesterday we reported shortage of electoral materials. So how then can we start with validation?
The EC has brought this onto itself. I'm telling you.
How?
They brought it onto itself. There has been series of agitations, not today, to clean up the register. Not today.
But the EC says that it has its own way of making the register clean,
my sister,
which they do all the time.
My sister, its own way. The question, what is the way? Since 2012 elections, the Supreme Court election petition, all right, 2013,
the reform
and the judgment and the reform that they said they should go and do. Have you heard in this country that the EC said, well, there is a roadmap for the reforms?
Yes. No, Gary, if you are not aware, IPAC met all the political parties and agreed on 27 reforms. And this reform, and remember that the reforms are in different respects. One, on even how the pink shades, if I may rightly point out, how it should look, were all part of the reform, which was agreed at
you are taking my time.
Very
taking my time.
Very
See,
well. So continue.
The point I'm making is that it is different going to sit in your conference room at the EC head office and then taking decisions and then going to the ground itself to go and do some work. What I'm talking about now is on the ground. What has the EC done on the ground? That's my concern. Now, between 2012, 2013, 2014, and now, 2016, where we are now, the EC has not taken any concrete step on the ground to ensure that the voter registration document, which is the parent document upon which this election is being conducted, has been cleaned up. Nothing. In fact, all the demonstrations which have been going on, they have not bothered. They have not bothered. So where we are now, they have to do this work before the elections. It is immaterial whether the elections will come on in December 7th or November 7th. They have to do this work before the elections. And they say immediately. So it's forthwith. So now, how are they going to do this work between now and November and December? It's up to them. But I'm saying they brought it onto themselves. Because
but
if
for the demonstrations,
I don't understand
No.
when you say they brought it on.
they have brought it onto themselves, because the posturing of the EC chair between the time that she took office up to now, look, she has not, in my view, demonstrated enough commitment to ensure that the voter registration, the document itself, is breadth of the challenges in the document. She hasn't done that.
Why do you say so? Because after the demonstrations and the agitations, there was a committee set up to get to understand whether indeed we needed a new register. And the committee said, we do not.
Look, my sister, even before the committee was set up, all right, there was a petition to the EC that there are certain dead persons on the roll. There are foreigners on the roll. All right? There are minors on the roll. What did they do? What they did was not even to respond to the petition, but rather to set up a committee to invite memos from all stakeholders. Now, look at the committee's report. The committee itself said that the exhibition processes is not effective. And let's be frank here. How many times have they done exhibition that people have gone to queue to go and find out whether their names are actually in there, to correct the names or not to correct the names? How many people go? No, people don't go. So the question is that if you don't go or you go, before you are aware, on the election day, when they go, sometimes their names will not be there or the names may be there. So that process is not effective. So how then do you come out and say that the same process that is not effective should be used to do what they call cleanup, or to identify people who are dead or those who are not dead? How do you do that? That is why people are saying that, look, let people go to the election, the polling centers across the country, go and identify whether your name is there or your name is not there. So that if at the end of the day, you go and then you see your name in the voter register, more or less, we all agree that, oh, you actually exist. You are not dead, you are alive. And that's the form of what we call validation. It's only a term of art.
No, validation is not
Wait.
The danger is when you associate validation as a term of art, then you are acting that it should be done in a particular manner. And that is why the Supreme Court throws that caution that relative to the independence of the Electoral Commission, asking the EC to conduct validation in a particular manner would amount to unlawful interference in its duty. You agree with me?
Fine. So now, this process, where it was a simple process of people appearing at polling stations or the centers to come and say, well, my name is GhOne Edugitamaku. Take my name or put your hand on the machine to be verified.
And if I don't,
how many people are willing to leave their jobs?
Exactly, if I don't,
so now the bottom line, the EC says, I will not go through this process. Now you are told to go and delete names. Now you are told to go and ensure the persons who are dead, their names are no longer on the electoral album. All right. Between now and when they will now compile the final register of voters who are qualified to vote in this country, this work is a very tedious work for them now. The first one, in my view.
My lady, do you know that? Do you know that? No, just a minute, so that you come.
No, don't interrupt.
My lady, can you imagine that if you take, for instance, you take this dead person's name today, okay, others are on the register. By November 7th, are you sure that we may not have any other person dying on the register?
That is not a fact. That's
exactly.
Therefore,
and you see the unique character which the Supreme Court alluded to is that the current register has a unique feature of your fingerprint. Dead men can't thumbprint. They die with their thumbprint. So of what moment is it, even if it's dead and it's on the register? How is it going to wake up? By the process of verification. How do you get a dead person to come and thumbprint?
So from
let me show you how.
Yes.
Let me show you how. Okay, you put a question.
Let me see if I understand him. So what you are saying is that even if we delete the names of dead persons now, by November 2nd,
we'll still have dead people.
We'll still have them, and so that verification that you go through on voting
cures
day
that
should
mischief.
be enough
to cure that mischief. Because you see, at that point, until your fingerprint is put on the machine, which obviously a dead person cannot do, you cannot vote. Be it manual or using the BVD.
You see, my sister, all this is propaganda.
Oh, my brother.
Let me tell you. You see, yes, it is correct. That even between the hours of even 8 o'clock to 10 o'clock, somebody may pass on.
Yeah.
It is correct. Now, between 2012 and now, the people who might have died in this country is more than people who obviously will die between now and 2016 elections. No doubt about that. Now, nobody is saying that people will not die. But we are saying compile a reasonably credible register. It does not mean that the register will be 100% foolproof. It doesn't mean that.
Okay.
Reasonably credible does not mean that it's 100% foolproof.
Okay.
It means that the error of margin should be minimized. Now, let me explain to you what they call the classical definition of overvoting.
You want us to go back?
You see, when you have people who are dead on the register, the danger is that on the election day, assuming for certain polling station, number of voters, for instance, let's say are 5,000, all right? And then 3,000 came to vote. And then when the counting is done, you realize that, well, it's 3,000 who came to vote. Obviously, some will be spoiled, maybe about 200 or whatever is spoiled. The 5,000 that is there, then you will see the
pink sheets.
You see that the thing is being padded up, all right? They go and pad it up.
How?
And when they pad it up, then when you complain,
Cancel how?
when you complain,
How
that,
is the padding going to be done? Cancel.
But this thing happened in the Supreme Court 2017. No, we saw it. We saw it. We saw it there.
You see, let us
Wait.
You proceed.
When they padded up and it does not exceed the number of voters on the register, they say there is no overvoting.
Classic.
All right, classical. Now,
What are
see,
the
it is better that you minimize all these things because see, I hold a view dear to my heart that elections ought to be won and won in a manner that the loser understands that I went to a battlefield and I've lost. The winner understands that I went to a battlefield and I won fairly. And you see, winning fairly, the parent document that must be used to win the election or lose the election should be reasonably credible. And therefore, if you have a voter document where at the end of the day people are complaining and you yourself you admit that that document to some extent has challenges on it, you cannot say that you will not do anything about it, or you want to do it in your own way. In your own way, you are saying you are going to do is that you are going to do exhibition. So exhibition, how do we know those who are dead? How do you know those who are? How do you do it? Because it's possible that the people who are dead on the register, obviously they will not appear, but it's possible that though they don't appear, their names will still be on the register without even being removed. If nobody comes forward with the document that look, this person is dead, and therefore the proof is that there's a death certificate or barrier certificate or barrier permit or cause of death, whatever it is, the name will still be there. Because see, it is not easy to delete people's name from the register. Because when you delete maybe my name and I think I'm alive, you delete my name and I find out that you deleted my name maybe at the exhibition stage, I will take it to court. Then why we deleted my name? So that is why I'm saying the deletion of the names is not going to be an easy task. So you must publish the names of the people you're going to delete for them to know that I am, you see, I use NHIS card on this day. So I know. I mean, you're putting me on notice. That is how it's going to be done. So the EC, now they have a bigger task.
But Gary, let me just
and they're going to do this across the country.
Let me give you a reference so it helps you.
Yes.
Relative to the issue of dead persons, this is what the court said. We think that the elaborate scheme provided the law is sufficient to address the presence on the register of voters of names of persons who might have died since the last registration exercise.
No, go forward. Go before you.
Yes.
One.
No, if you
backtrack
a conclusion.
If you backtrack a bit,
notwithstanding, the indicator, you said the unhappy situation, however, is that the system of registration of births and deaths in the country is woefully behind the current trends in development. This had the effect of rendering the current register of voters not reasonably accurate or credible.
Right.
We do not, however, think that the defect is too extensive in nature to result in an inconsistency with Article 45A of the Constitution, as the existing law had made ample provision for such names to be deleted when the provisional register is exhibited. So that's what the court is saying. And proceed further to say that, yes, page 20, and proceed further to say that we think that the elaborate scheme provided the law is sufficient to address the presence of dead persons on the register. I am even making further contention is this, that relative to the issue of dead persons, of what moment are they? What is their effect? Assuming you even have 1 million dead persons on the register, the basic feature of this voters register, which nobody has controverted, is the issue of your unique fingerprint. On what basis, therefore, can a dead person be deemed to have, come for the purpose of registration? Where are you going to do the verification? Where are you going to put your thumb?
It's easier said than done.
That is a fact. Nobody has controverted that basic feature of the biometric process.
It's easier said than done. These my friends.
Oh, no.
Dead can resurrect.
No. In fact, like they said, dead men can't imprint. So that's the basic truth.
Gary, so for you, the exhibition isn't enough.
At all.
But you see, what Gary had failed is also prescribed beyond deletion any other means of doing so. Because deletion, you cannot on the face of it do a wholesale deletion of dead people. How do you even identify the person is dead if the family member has not come up?
Yeah, that is why I think that the EC itself ought to confer also with the birth and death registry,
which is inadequate.
But we don't have the accurate statistics at the birth and death registry as we speak.
At the end of the day, the catchment phrase is that the register should be reasonably credible.
Okay.
It does not mean that the register should be full proof or 100% proof that there's no problem with it. I mean, we can't have a register which obviously you can say that, well, there is no problem with the register. It's not possible. But as it stands now, in this current state now, there are difficulties with the register. And everybody admits. But my difficulty is that why have they taken so long? So long until now.
But Gary and his friends have always been on the street instead of allowing the EC to do its work.
Well, there are more cases that is going to come up. You see, now, even with limited registration, all right? Have you heard about GhOne, University of Ghana?
There are issues, not just GhOne,
and other universities
in the country,
where they are giving them even only one polling station with huge numbers of the universities. They want to disenfranchise them. Are you aware? And EC, as of today,
but Gary, so that we don't appear to be sounding the alarm bell now, even the CI 91, the new 87, sorry, the new CI.
It's 91.
91, sorry. It allows for even continuous registration. You agree with me? So that even today, assuming within this limited process, you're unable to register, the law permits you to register. We should also use this opportunity to let people know that under our current, legal arrangement, the law permits continuous registration. In fact, as early as 1996, the Supreme Court in Tenadi versus Attorney General had already taken the position that on any time that you want to register, you should be able to do. And subsequent CIs have always had this provision that allows for continuous registration. So this problem in the University of Ghana and other places, I think can be resolved if we let people know that beyond today's limited registration exercise, you can still unveil yourself for the process of registering.
So in view of that,
it's permissible.
So in view of that, the EC should not mount enough polling stations or registration centers to register the people?
If you recall, on the election day in 2012, if you recall, some polling stations had challenges. So immediately they had to do
another centers.
Do you know that it was one of the grounds for which reason the election petition was mounted? Quote, those unknown polling stations that became the basis of this. So I'm saying that this is a matter that we can resolve without having to...
With all these concerns and issues we are raising about the Supreme Court ruling, then it raises the questions about how practicable this whole thing is.
That's the issue.
It will be practical one. This ruling will be enforced before the elections. If as a matter of fact, if I were to my advice would be sought by the flag bearer of my party, whether or not we should go into elections with before this is done, I would say, look, let's wait. Let them clear all the hurdles along the way, and ensure that the register is clean, is reasonably fair, is credible, to be used to conduct elections before the election can be done. Because this order will be complied with.
My lady, if I may find out from my friend. No, if I may find out from my friend.
How soon can we do what? This work?
If I may find out from
I said they brought it onto themselves, so they must do it.
Gary,
they must comply with it.
The presence of dead people on the register, granted it exists, to what extent does it disadvantage any of the competitors in the electoral process? Oh. Assuming there is the presence of persons with NHIS card on the register, to what extent does it compromise the free, fair, and transparent conduct of the election?
But if someone registered with an NHIS card and the person isn't Ghanaian?
Because, no. The issue,
because those are some of the issues that have been raised.
Because, you see, as we speak, we cannot tell that the person who registered with NHIS. So the difficulty is that this process does not in any way disadvantage anybody. You know it.
No, you are taking us back. You see, you are taking us back. The NHIS card in its form, all right?
Does not show.
Does not even tell you who's a Ghanaian, who's not a Ghanaian. In fact, the card itself, by the law that even made the card itself come into existence, allowed everybody who is in the country to go and get a card once you pay. Now, if this card is being used to register people and put them on a roll, in the roll which obviously is meant for only citizens, there's a problem somewhere. You understand? So if you have Togolese, you have Nigerians who are living here, you have Burkinabes who are living here, you have Arab who are living here, all who the NHIS card, why should they use a card to vote in an election which is meant for only Ghanaian citizens? So that is the reason why the Supreme Court said, look, that document itself, to be used to put your name on the roll, is unconstitutional. And therefore now, if you have used that document, because it's been declared unconstitutional, we are now saying that, look, clear everybody off with that name, all right, and ensure that those people, because they might be Ghanaians. Because you see, as I said, somebody has an NHIS card. It doesn't mean that he's not a Ghanaian. It is possible that the person is a Ghanaian.
Just as it's possible that somebody with driver's license may not be a Ghanaian. It's possible, right?
But the driver's license, the Ghanaian is there.
No,
but there's no such indicator on the NHIS card.
Yes.
But the point I want to make is that persons who go for a driver's license, because he wants to benefit from driving, he may have the name Chiki or Chumeku or whatever, but he still comes across as a Ghanaian. He speaks typical Nigerian accent. But he comes and tells you, yeah, he is. And he gets a Ghanaian driver's license. And he uses that for the purpose of registration.
Yeah, so are you saying that
we come back to
are you saying that because that's what the institutions must work?
No, but you say institutional lapses exist.
Let me find out from you. How would you want the EC to do this? We've got just 6 months to elections.
Well, I would have expected them that today they will have mounted
giant billboard.
Don't forget the ongoing registration exercise.
It's independent of what is going on. This is a different order. This is a court order. This is going to be complied with. It's a court order, whether they like it or not. It's an order.
Yeah. So how do
if they
you
don't
want them to
comply with this one?
To comply
the consequences are different. Now, I would have expected them that from today, they will assemble all their staff, all their district staffs, and say, look, can we have all the Form 1C immediately? All right, display them per spreadsheet on all the tabloids in the vicinity or the locality, because it's district by district. Okay, display them all over. Now, when you finish, you make public announcement. They do work with the NCC and go around the communities and make announcement. Go. Look, anybody with NHIS card, go and check your name. Or your name is being displayed. If you know you use your NHIS, go and check your name. We are going to delete your names. See, you must give the people the notice, opportunity to come and say, well, okay, yes, NHIS, that we use NHIS card, but we are Ghanaians. It's another document that we have. Or 2 people come and guarantee for you. All right? And ensure that all the people, the names are all listed there so that we know. And we must know. All the parties must know. Else what they will do is that they can, out of mischief, enter into a region. All right, and say, well, this region that we are entering, we suspect that this is an opposition stronghold. All right, and then delete about 1 million people from the register.
So, for instance, I didn't register in Accra. How do I know that I have been affected? I don't remember what I registered with.
That's what I'm saying, that they have to publish it.
Publish it?
Yeah, publish it.
At the
names.
local assemblies?
No, at the districts.
At the districts?
Yeah, the local areas.
Okay, I am in Accra now. So I'd have to
you have to go back. You have
to
go back to
and
the
then
districts.
the inconveniences.
Well, you know, you want to vote. You see, that's why you can go.
So
there.
if I'm unable to do that, then I'll be disenfranchised.
No, but when they delete your name, the opportunity will come for you to re-register.
At what time?
At the time that you don't show up, they will delete
you see, that is why I'm saying that this decision by the Supreme Court.
Because you see, no, wait. They will delete your name because it's very clear. They are saying that delete the names forthwith or immediately. It's immediately. They didn't say go and delete the names in 2 weeks' time or 3 weeks' time, 1 month time. Immediately. And immediately means immediately. Go and do it, you see? Go and do it immediately. So today, they should have started working on this matter today.
Okay.
All right? And then, when they do the publication, and then you know that your name has been published, including using the major tabloids, Daily Graphic, all of them, everybody. Look. Then you now know that your name has been published. You go, and then make sure they take your name off and register. Simple. If they don't do that, they are going to be in contempt of the judgment of the Supreme Court.
Right. Okay. We would have to take a break at this point. When we return, I'll take your final comments on that before we get into our second subject for discussion this evening, right here on State of Affairs on GhOne TV. As always, you can be part of the discussion using any of our social media platforms, Facebook, Twitter, and Instagram at GhOne TV. Don't forget to use the hashtag State of Affairs. And 8th May is Mother's Day. She was first your mother and will always be your friend. Send us a 2-minute video telling your mother how much you appreciate her and tell her why she's the best mom that ever was. Tell Mama one thing that you will always love and be grateful for. Here at GhOne TV, we are simply loving our mothers, and so should you. So say it all with a video. Send it via any of our social media platforms, Facebook, Twitter, and Instagram, or via WhatsApp on 0231 144 272. We are looking forward to that video that you will use to say thank you to your mother. After the break, we'll be taking a look at another ruling by the Supreme Court also yesterday. It has declared that Section 967 of Act 30, 967 of Act 30 is now unconstitutional, and thus all criminal offences are henceforth bailable. What exactly does this mean? We'll be delving into that right after this break. You're back on State of Affairs right here on GhOne TV. Before we went for the break, we were talking about the Supreme Court ruling directing the EC to delete names of persons who registered with the NHIS cards, dead persons, and also minors from the register. I'm going to take some of your tweets coming in, and then I'll take the final word from GhOne on how he wants the Electoral Commission to undertake this particular directive. So there's one from Manuel K, and he says, last elections, the Supreme Court said no verification by the machine, meaning no vote, is disenfranchising the person. And Abdul Rafi Mohammed says intolerance in itself is a form of violence and an obstacle to the growth of democracy. Samuel Brian Boabeng tweets at us and says, the Supreme Court of Ghana has spoken. Mrs. Charlotte say cannot hold us to ransom. The EC is not her personal property to be on her whims and caprices. Okay, so those were some of the tweets here. And so, GhOne, how best do you want the EC to go about this directive? Clearly, in 1 minute.
Clearly, as the Supreme Court itself made the point clear, that there is an elaborate process sanctioned by law for the purposes of deleting or cleaning up the register. Significantly, in this particular judgment, at any time they use the word deleted, they always, counts with this is disjointed deleting or cleaning up. I think that that was done for a certain practical purpose, because as we have done here by way of our discussion, we have already indicated the practical difficulty that comes with it. And at all material time, the court had made the point very clear that this decision should not be construed as a means to disenfranchise persons who are registered. Now, we need to know that at the time when those who registered with NHIS card did so, it was permissible by law. So today, and like the court rightly pointed out, you cannot punish them because they are not benefiting from a certain wrong. We come back to a position that I refer to, the +1 - 1 situation, where you are deleting and still giving him the opportunity to get registered. Let's take it that all the persons who registered with NHIS unveil themselves again for the purposes of registering. And I have always contended, relative to the issue of citizenship, our citizenship law is one of the most confusing one, so to speak. Because, like I always say, as early as 31st July 1969, the son of a Togolese president, Declears was declared by High Court of Ghana to be a citizen of Ghana by reason of having one parent being a Ghanaian. And there are many other persons who fall in that category. So the person comes with a very fanciful name, but he's a Ghanaian. So you cannot say, beyond the Ghanaianness, what other basis will you say that somebody should not when he's a full-grown person? Like the issue of minors, for instance. Assuming the person was 15 in 2012. Today he should be 18, right?
Yeah.
So that if you delete his name, assuming, the effect is that he comes back now to register.
So how should the EC go about this?
And let's even look at it this way.
Answer the question.
The NHIS card.
Answer the question.
The NHIS
We don't
card.
have limited.
You know the
time.
NHIS card. Between the NHIS card and just having two people to come and stand in and say you are for the purposes of qualification to be registered, which one would you have preferred? But that's just a matter for. I think that the EC, through its exhibition process, can be the purpose of doing or cleaning up this register.
How?
Once you unveil yourself, to that process.
If you don't,
your name should remain. Because you see, if I register Gary, let's put it this way. I registered in 2012. For the purpose of studies, I need to do possibly an LLM, traveled abroad. But I know I'll be back before November the 7th. And then you are saying that because I did not come to look whether or not my name or whatever is on the register, I should be deleted.
So you think
Do you think that will be helpful?
and you use NHIS card, and the name should remain on the roll?
But
No, I'm asking you. Use NHIS card.
Yes.
And the Supreme Court says go and delete the names immediately.
But you see, the court is saying that the court has even made a point that, first of all, the law should not be construed as what? To disenfranchise you.
Okay, so
and you should be given the opportunity.
If I do not avail myself during the exhibition,
Yes.
my name should still be maintained in the register.
In fact, you know something? I remember when my friend and Nana Santi Bedie too, I remember that day in court, when they did the first Abu Ramadan case, the question was put to him, because one of the relief was that if the court take the view that the use of the NHIS card was unconstitutional, there should be a further order to delete the name.
Well,
the court
we would
said
have
those
to move on at
individuals
this
should be
point.
given a hearing. To what end would you say? Even for the purpose of service. Service on somebody, a process, to serve a process. At what point would you say that? No, it's not the order. The order should be complied by giving the person notice.
All right,
How would you
gentlemen,
do that?
let's just
Practical.
move on at this point and move on to our other topic. There's a message for you here, Gary. And Abdul Salam Kasalgu says, Gary, please, you're doing great. You're doing a great work, but unfortunately, you do not belong to the winning team. That's the end. That's a message here for you. So while we are moving on,
Gary will disagree with you.
to the ruling about the non-bailable offences, and this Section 96(7) of Act 30, as amended, states, and I quote, "A court shall refuse to grant bail in a case of treason, subversion, murder, robbery, hijacking, piracy, rape, and defilement or escape from lawful custody, or as amended by the criminal procedure, where a person is being held for extradition to a foreign country." This new position of the court, Gary, what does it mean?
Well, you see, as a defense lawyer, if you ask me what this thing means, I will say simply that it's a very good position of the law as espoused by the Supreme Court. You see, there is a constitutional presumption of innocence that when you are accused of a criminal offense, the presumption is that you are innocent until proven guilty. Now, these offenses, as you rightly listed, in fact, including narcotics, and rape and other things, were offenses that, strictly speaking, were said to be offenses that when you are alleged to have committed them, there's a complete no-no to bail. Unless under exceptional circumstances, you can show the court that one, there has been unreasonable delay in the trial, or maybe two, out of medical grounds, the person, if he kept in custody, obviously, some unpalatable consequences might occasion the accused person, maybe including death. And I don't think the Republic's interest is to keep somebody in custody prior to trial and kill the person. So they will grant you bail under those exceptional circumstances. I've always had a view that that position is a bit quiet to some extent. And I will weigh the two balance for you to see why I hold that view. It's a bit, sometimes a bit absurd. Why? Because you see, sometimes, and I'm not saying all the time, sometimes, I might have a problem possibly with you, or a client might have a problem with the girlfriend. The girlfriend makes certain demands. The client is unable to meet the demands. They have normal sexual intercourse. The girlfriend walks to the police with an exhibit of it and say, well, the guy has raped me. And at that time, they might have the sperm, obviously, in the pants. And you know, once the police invite you and you go, they'll say, well, this is a say the lady say you have raped her, so non-bailable. And at that time, you are kept in custody, and nobody will give you bail. If I will go to the High Court, you will not get a bail unless you can show the exceptional circumstances before you can be given bail. And you see, you can see a lawyer in court, you can talk for 2 hours, you will not get a bail.
They will knock you down.
Because they will say, Attorney General will come and tell you that, look, my lord, your hands are tied because
it's an
unbailable offense. Now, there are also times that the police themselves have used this law as a sword. All right? Certain facts, which may not be murder, they will say the facts are murder, and they will charge murder. But the facts that they will support the murder charge will not fit the murder charge. You get what I'm saying? There are certain factual situations that should fit the offense called murder. But the facts will not support the charge of murder.
Okay.
But they put a charge murder there. And when you go to court, the judge will see the murder and say, oh, murder. And they say, unbailable. And you have to argue to distinguish why, in your view, the facts do not support the charge of murder. And for that reason, the court is not bound. All right? And then also to exercise its discretion to grant bail. Now, bail is a discretionary remedy. It is not bound on the court. That even for the bailable offenses, once you say it's a bailable offense, the court must give you bail. No, it's not like that. The judge, in his wisdom, will have to assess the totality of the circumstances, and then come to the conclusion whether you refuse you bail or you grant you bail. Even with these offenses, which now have been declared unconstitutional in terms of bail, it does not mean that when you go to court and you have been charged with, yes, it doesn't mean that.
Okay.
It doesn't mean that when you appear in court and it is treason, Then the court to say, because they say it's non-bailable, now it's bailable, I'm granting you bail. No. The judge will look at the factual situation, will look at all the circumstances and see whether if you grant you bail, one, you will not go and even interfere with the witnesses, even interfere with the evidence, all right? You will not even go and influence certain characters to ensure that certain things are done in a manner that will be prejudicial to the trial. In fact, maybe you are somebody who have even been jumping bail when you are giving bail. They will not give you bail.
Well,
So you see, a lot of factors will come into play. So nobody should be disillusioned and be thinking that because they say now narcotics is bailable, you can go and put narcotics in your stomach and then be going to London with the narcotics. And then when you are arrested, immediately you'll be given bail. It is not like that. So the court will look at all the facts, all the circumstances, and then decide whether to grant bail or not to grant bail. But I think that with this position of the law now, it's good in the sense that it will make the work of the lawyers, the work of the judges, the work of the attorney general people now a bit more scrutinized. Because now you don't go to court and just say because it is an unbailable offense, they will just come to court and say, my lord, it's an unbailable offense, your hands are tied. So they will just sit back and watch the judge. And the judge will now sit and say, well, it's an unbailable. So, and they will say, oh, how long have you been in custody? They say 1 year or 6 months. So, but it's not that long. Go and wait and be there small. And if you are not careful, an innocent person will be in custody for God knows how long. Sometimes they've been on remand. Their documents are missing. All right, they've been on remand. Sometimes they say the Black Maria or whatever they call it, that truck is not bringing them to court. The visitor is transferred, and then all manner of things happen. And people are on remand, 5 years, 6 years, 10 years, and they are just there.
Right. GhOne, there are claims that this particular ruling will give too much authority to the judges, and it could be an incentive for them to take bribes.
Oh, no.
I mean, that is, for want of a better word, far-fetched. What I think that this ruling has done is to once again put at the core of our democracy the respect of personal liberty. Like my learned friend indicated, the danger with the non-bailable offenses is that the very moment the charge is put in court that you are charged, count one, so, contrary to this, and on the facts, it looks like murder, it looks like defilement, it looks like rape, that will mean that you have to go out there. So that if your trial is going to take 4 years or 3 years, the very moment you are consistently coming to court is enough for you to be kept there, even if the facts do not support the charge. Today, what the Supreme Court is saying is that all of these offenses are bailable. What this decision has not taken away is what you call judicial discretion. So that at all material time, the trial court judge would have the benefit of examining the peculiar fact of every case to say that, okay, this individual, you are flight risk. Deposit your passport here. Do this. The even more dangerous thing now is that in the past, if you stand surety for somebody and the person absconds or something, the law can deal with you. But today what we have is that even sureties and the recognizance and others are deemed contractual. So the best the AG can do is to bring a breach of contract against you and to enforce that in a civil process and no more a criminal process. Thankfully, it's the same Martin Kpebu who has done both cases.
Yes.
And I must say that kudos to him, he's done very well. But what this particular ruling is going to do is to help all of us. Young man out there, your girlfriend can just say you've raped her, and the next thing is that you are processed to the court, taken to court. The next 2 minutes you are remanded because it's non-bailable. And you're going to be there for God knows how many times or how many years until set time that the verdict. If at the end of the day, but you see, significant thing that we must always appreciate with our criminal jurisprudence is the presumption of innocence until the person is proven guilty. And that presumption takes its root from what have you, from biblical times till now. You understand? So, you know, that presumption of innocence also raises another presumption as to say your right to be granted bail. And that, for me, is the crux of this whole ruling. And I'm excited that the Supreme Court has finally struck down Section 96.7 of Act 30 that is inconsistent with Articles 14 and 19.2c. It has always been the argument that has been put forward, particularly in the GhOne and the Republic case, which the Supreme Court then said was very lawful. Now, with the benefit of hindsight, the same court has corrected that problem to say that now, by 5-2 decision, will prefer that at the core of this must be the respect of personal liberties by ensuring that whatever crime it is that a person is charged with, he should have that right to be granted bail.
Well, there's a message here from Kweku Mensah, and he says, does this really mean that suspects, and for that is murderers, would they be just let loose?
It's important that even when somebody is taken to court, he's still deemed to be an accused person.
So such
and that is
accused
where
persons,
the presumption of innocence until proven guilty. You see, the right to bail or to be granted bail runs together with that presumption of innocence. Because you see, if you are innocent, ordinarily, why should you be kept behind bars?
but if you are not innocent
see,
and your lawyer is
you
able
see,
to secure bail for you,
I use the word judicial discretion. So the judge will sit down, look at the fact, look at your conduct, look at how you have, maybe the crime in question. The person says you came to rob. In the process of robbing, you proceeded to even rape or something else in the process. What in the fact is the key issue that, look, you were unmasked, somebody saw you. The judge will look at all these critical facts and say, look, at this circumstance, if I should grant you bail, you may go and hound the witnesses who or the person who saw you or encountered you. For which reason, even though there is a right to be granted bail, I will exercise my judicial discretion by keeping you behind bars. And for us as lawyers, even for the bailable offenses, when you go to court, you just don't say, it's not as of rights. The judge will still have to look at this and say, look, the facts do not support this charge, I'll grant you bail. Or the charge in fact supports it, but under the circumstance, I think that you do not, you are not any serious potential, in terms of risk to witnesses and others, or you are not even a flight risk, or you even have very good sureties who can stand and ensure your attendance to court. And on the basis of this, the court will then proceed to grant you bail. It does not mean that we want murderers, to be on the street, or armed robbers to be on the street, or rapists, or what have you, or persons who defile and to be on the street. Not at all. But just that the judge will have to look. This time around, there's no fetter on him that, though, because this statutorily is non-bailable, I cannot do anything. This time he can. He will look at the fact and decide.
well, Gary, and so are there any exceptions to this particular ruling?
Exception in terms of what?
As in the offenses that are bailable?
No, now what is happening is that now every offense, more or less, is potentially bailable.
Okay.
It's potentially bailable. I mean, every offense now is potentially bailable. So it means that if you decide to even overthrow the government of the day through unconstitutional means, it's potentially bailable. That is what it means. But you see, let us not forget one thing. The fact of being given bail does not mean the case has ended. You see, the bail only gives you a temporary reprieve. Let's go home whilst we do the trial. If you are on bail, it doesn't mean the case has ended. So if, for instance, this one, somebody asked me a question, that will it increase what they call instant mob action? Because the society will say, well, the man we arrested the man, we gave him to police, we took him to court, the lawyers have bailed him and brought him back. And then they will now go and pick the person and kill the person, or whatever it is. You see, what the public must understand is that the fact of being given bail, it does not mean that the case has ended. It simply means that, look, go home whilst we look into the matter, whilst we try the matter. If, for instance, the evidence supports the charge and the facts are such that, look, we realize that you have actually committed the offense, you go to prison. so that we don't unnecessarily overcrowd our prisons with these remand prisoners and overcrowd. Have you gone to prison before? To just go and visit.
Yeah, we've had stories.
No,
of,
no, you only heard.
You should one of these days have the benefit of
I've been
going.
to the Kumasi Central prisons before.
All right. What about someone?
No.
Look, I'll take you there one day. And when you go, and then they show you their sleeping place, in fact, how they sleep. They arrange them as if they are, excuse me, they are sardine or human beings. Yeah. But I can tell you, some of the people who are there, some are innocent. It doesn't mean that those who are there are all criminals. Some may have committed an offense, all right. They've been tried, they've been convicted, and they are there. Some too, for 10 years or even more years, they have not even been tried, and they are there as remand prisoners. Their documents have been misplaced. The investigator have been transferred. So it's a big problem. And for some reason, the CJ had to set up what they call a Justice for All program, and then they had to go around the prisons to try and decongest, the prisons because of these problems.
And now there's a court in Sawem.
Yeah. Exactly. So you see, I think that by and large, it is the way we have acted. When you appear in court, rape, remand, murder, remand, this, remand. I think
it's even more dangerous in the rural areas.
Of course.
Very, very dangerous. The abuse is just terrible. So I think that this is more progressive, and let's see how it helps in the whole criminal justice system.
I take those were your final words.
Absolutely.
Well, my final words will be to the EC that they should ensure that within at least these few coming days, from Monday to Friday, they should try and take steps to ensure that this decision is complied with forthwith. Because I can assure you that if they don't comply with the decision forthwith, there will be other legal suits against the same EC in court.
Okay.
I'm only giving them some free information.
All right.
To take steps, copious steps.
All right, GhOne, under 30 seconds.
I'm sure this legal suit, as my brother is saying, may now come with a direct way of how it should be done, and not through validation, which I think may not happen.
All right. Thank you very much, gentlemen. That was lawyer Gary Nimako and lawyer GhOne Tamaklo. Both are lawyers, so it was all law today. There's a message that seeks to reply the earlier one that I read, and it's from Sadat, and he says, I disagree with Abdul Salam. Gary is rather with the winning team. So
thank you very much, Allah.
Yeah, that's one for you. And so we are wrapping up the show. Don't forget that 8th of May, the Sunday, is Mother's Day.
Can I wish your mother Mother's Day?
Oh, yeah, I'm sure my producer will grant that right after this. Hold on. So she was your mother and she was your first love and she will always be your friend. Send us a 2-minute video telling your mother how much you appreciate her and tell her why she's the best mom that ever was. Tell Mama one thing that you will always love and be grateful for. Here at GhOne TV, we are simply loving our mothers, and so should you. So send us those videos via Facebook, Twitter, and Instagram, or on WhatsApp, 0231 144 272, and say thank you to Mom. So shortly, a message to your mothers.
Mrs. Mary Nimakon, I wish you happy Mother's Day. You've done a lot for us up to this stage.
Okay.
We thank you very much for all that you've done.
Yes, I will not leave my mom, Madam Philomena Antoso. She's been a wonderful mother, and my wife as well.
Indeed.
Yeah,
you failed to mention your
wife.
That's a great thing.
This is a bad man.
All right, that's right. I'm sure she knows you appreciate her. Okay, so we are wrapping up now. It's okay. GhOne just got married. Okay, congratulations to him. Thank you very much for watching the show. This has been State of Affairs on GhOne TV. My name is Abena Owusu-Nyameche. Do you have a great evening?